Good morning, everyone. Welcome to Gateway Office Hours. It's another Friday, and I'm your host, Ben Larson, co-founder of Gateway. I'm here with my co-founder, Carter Laren. Thank you again for joining us. This is episode 57, and we are now 2 weeks in a row of being together and me not abandoning you. So congratulations on that.
I can try and abandon you next week if you like. Oh, I am abandoning you next week.
We're going to do this live on the air right now?
Right? I'm in Miami for a conference.
All right, fine. Okay.
I never liked you anyway.
Yeah. Moving on, we're going to talk about California legalization efforts, the legal alphabet soup in the transition of getting cannabis businesses to 2018. There's been a litany of, propositions, Senate bills, groups, organizations, governing bodies, all have been introduced over the last couple of years, and it's confusing as hell. Prop 215, SB 420, MRSA, SB 94, Prop 64, Malcursa, Bum Kicker, and BCC. What's it all mean?
Can you finish your housekeeping? Talk about New West, YouTube, Facebook, all the stuff you're supposed to do. What kind of a host are you?
We could just save it for the end. But
all right, fine.
Sorry, you threw me off by ditching me next week.
Hi. Hi, guys.
Hey, Kieran, welcome back. Thank you for coming back. Kieran Ringenberg, if you don't know him, he super lawyer. Yes, that is right.
Yes.
He is our go-to for cannabis legalization questions. You've been a huge help, big help to companies coming through the program. I don't know if I should advertise this for you, but I feel like you're one of those lawyers where I can actually ask you a question and not be afraid that you're going to bill me for 8 minutes of your time.
Only 9 minutes you get a bill. 8 minutes you're free.
Okay.
It's
all
okay.
right, keep it under 9.
Yep,
got it.
That's the advice.
But thank you for coming back, and we're super excited just because there's a lot of news coming out about companies, the complications they're going to be facing as the 2018 regulations start to hit, and what it means for their business. So I know there's a lot of people out there that are curious. How does it affect their business?
Sure. And it's an interesting story, and the story is going to be tumultuousness because we're going to have some rules, and then we're going to change our mind about the rules are, and then we're going to change them again and again, and it's difficult for business planning. But the only thing you can do is keep up as best you can. Mm-hmm. Try to look forward and try to guess where things are headed. That's definitely a challenge.
Why don't we start with a little bit of history, because I think Ben read a lot of there's a lot of letters, mostly consonants,
city here,
that were sitting over on his piece of paper there.
Yeah.
Not everyone is familiar with the kind of history of California law, and just to be clear, we're talking about California here, not another state.
Right.
Can you just give us a high level?
Sure, thanks. California voters had the bright idea of legalizing medical cannabis in 1996 with what was the Prop 215, also called the Compassionate Use Act, the first acronym, CUA, still used in some cases. It's a paragraph. It's in the state constitution and can't be changed by the legislature easily. So it's been enshrined. There's no regulations with that. It's basically gave birth to the Wild West that is medical cannabis in California. Some years later, the state tried to put some boundaries around it and enacted Senate Bill 420, which set in place the collective cultivation regime that is the predominant form in which people have done business over the last 10 years. So, if anyone who's doing commercial business legally or semi-legally in California, you have a medical collective, it's supposed to be a closed-loop system. Cannabis is cultivated by patients, for patients, and in a nonprofit model. So that's the way it's been operating. So everyone who's in business today, that's supposed to be how they're doing their business. And so in 2015, the state imposed the first real regulatory structure on the medical market, and that was called the Medical Marijuana Regulation and Safety Act, MMRSA. Later, that was changed to the MCRSA when the state figured out that marijuana is a loaded term and we should really call it by its scientific name, which is cannabis. And that imposed statewide licensing, created the Bureau of Medical Cannabis, Bureau of Medical Marijuana Regulation, BMMR, which people called BUMMR. That's since been changed to the Bureau of Medical Cannabis Regulation, BMCR, which I called Bum Kicker. I couldn't get people to buy into that.
I don't know why. I think it's an awesome name.
I couldn't do it. And then of course in the last November elections, the voters passed Prop 64, also called the Adult Use of Marijuana Act, or ALMA, another acronym. So that set in place a regulation and legalization of non-medical adult use or recreational cannabis, which is really going to kick off next year. So at that point, we had two competing systems. We had the MCRSA system for medical and the Prop 64 ALMA system for recreational, and in many respects, they were different. They had some different licensing types. They were not entirely opposed to each other, but they did have some quirks between them. So a couple of things that people noticed. The medical system had mandatory third-party distribution. Mm-hmm. So you had to have a distributor involved in the chain of distribution, and it couldn't be owned by the same person who owns the cultivation facility, for example. So that caused a lot of people a lot of heartburn. Another example was there was a transportation license. So to transport from A to B, you had to get a separate license for that. The Prop 64 didn't have either of those qualities. So just in July, the state legislature reconciled the two systems, the recreational or adult use system and the medical system, into a combined program now called the Medicinal and Adult Use Cannabis Regulation and Safety Act, which I don't have a great acronym for. People call it MALCRSA. I think we can do better. We got to come up with something good, but that's where it stands. So now that the state is going to jump into licensing starting next year for both programs. Both medical and non-medical, and and that's where things stand. So it's an exciting time, but it also means a lot of changes because people who are making business plans based on the existing law now may have to pivot. So anyone, for example, who's going to have a transportation business, that license doesn't exist anymore. So sorry.
Right, and even the kind of present state MALCRSA, I actually think it's kind of a funny acronym. We can go with MALCRSA.
MALCRSA.
Even that's not really set in stone, right? It's not clear that that's going to last for years.
No, I think that's correct. I suspect we will see changes. I think we will see, but my guess is there'll be more incremental changes. I mean, that's a political prediction, so who knows, right?
Right.
But my guess would be this is the fundamental path we're on. One reason for that is Prop 64 was passed by the voters. So to change Prop 64, you need a 2/3 majority of the state legislature and for them to say it's serving the purposes of Prop 64. So it really constrains what the legislature can do. So one of the things that MALCRSA did, SB 94, which enacted MALCRSA, did is really bring the medical system into the Prop 64 framework. And since that framework can't really be changed easily, I think we're likely to continue in that same general idea as
sure.
now.
But some nuances that can some of those nuances can really impact businesses, though.
Absolutely. Like there's a bill pending in front of the state legislature which would prohibit branded merchandise. Mm-hmm. So, for example, they don't. The goal is they don't want T-shirts with the name of your cannabis company on it being sold on the street or being available on the street. And so it looks like that's very likely to pass. A lot of people in the industry aren't very happy about that. But that's an example.
It's one of the only ways you can kind of protect your trademark until federal legalization as well, is to kind of use your trademark on things that aren't cannabis related. And so it really is it's kind of a poison pill for a lot of businesses that maybe legislators know, or maybe they don't. I don't know.
I don't think that's the motivation. I think the motivation is to limit advertising to kids. That's the stated motivation. I think it is the real motivation.
Yep.
I don't think there's an agenda there. I think there may be some tweaking of that, but I think this is something the industry is going to have to deal with. I know some people are talking about raising First Amendment challenges to that. I'd be curious to see how that goes. My expectation is the industry is just going to have to live with it. If nothing else, it's going to be unsettled, and the regulator is going to have to enforce it. And so even though it might be a violation of the First Amendment, like it's debatable, but it might be, if the regulator says it's the law and you want to keep your license, you kind of got to do what the regulator says.
Can cigarette companies can make T-shirts with their brand, or no?
There are many states that have limited the cigarette advertising. There has been some First Amendment litigation around that, but for the most part, the tobacco industry just accepts it because they have a fundamental PR issue.
I'm just looking to that as an example, perhaps. But
you won't see a lot of Joe Campbell T-shirts anymore, right?
Okay.
And there's a reason for that.
So there's some ambiguity around how that bill is written, and that it didn't really define like what was branded merchandise, right? Like there was a question around uniforms for employees and that kind of stuff. Like, have they cleared that up a little bit, or is it still just going to be kind of up to interpretation?
The current draft legislation does not address that. It's very broad in general, and there's not explicit authority in the statute for any regulator to really take charge of it. But I would suspect that the Bureau of Cannabis Control and BCC and the other regulating agencies probably will have some interpretation to give people some clearance. I think, if you're, the other thing is you can have a name brand that's not the name of the cannabis product. That could be, so you could have your company name that's whatever it is, and your cannabis product might have a different name. You'd still be allowed to advertise your company's name on T-shirts and other merchandise. You just couldn't, whatever the name of the cannabis product is. That's not what that's what they don't want on a T-shirt that a kid could see. That's the idea.
Gotcha. So you had mentioned transportation briefly, and there's a lot of question about transportation. There's people out there, rounding up their distribution licenses. There's delivery companies. Can you dig into kind of what you meant by transportation and kind of break that down for us?
Yeah, you bet. So originally under the MCRSA, there was a separate license type called transportation. So if you needed to get your product from the cultivator to the manufacturer or to a distributor or to a retailer, to move it from point A to B, you needed a transportation license. And I think most people assumed that would go hand in hand with distribution, but it didn't have to be. You could have a transportation license independent of that. The Malcursa Prop 64 model does not have a separate license type for that. Instead, each other license includes in it the power to transport your product to the next stage of distribution. So cultivator would have the legal right to transport to the manufacturing facility or to a distributor, for example. In practice, I suspect that most distributors probably will take care of that, and there's still going to have to be a distributor involved. But that's what'll happen. I think that's better because it'll let the market sort out where's the efficient way to do this. The regulators are still going to control the mode of transportation, security, and everything, tracking, everything else. But you don't have to have a separate company involved necessarily. Delivery, that's another big change in Prop 64. So the medical system didn't have express authority for delivery services to retail, meaning you're at home, you pick up your phone, you put up an app, and you order whatever you're going to order. The medical system, that wasn't clearly authorized. So it clearly is under Prop 64, and now under Malcursa, they say expressly you can have a retail store that doesn't have an open to a public-facing business. They're just going to do delivery, which obviously there's a lot of people operating under that model in the market now, and so that gives them a way to move into the license system in an effective way. I think how that works in practice, we don't really know. There's no draft regs on that. So for the other businesses, cultivation, retail, manufacturing, the state government issued draft regulations that govern everything. And while those are not operative anymore, those are going to be withdrawn because they don't take into account the changes of the new regulation. They at least give some idea for where the regulators are headed on all these issues. Delivery, there's no draft reg, so we don't really know. The statute's pretty bare bones about what it says about what you do, what you can do and can't do, and what you're required to do. So I suspect in the next few weeks or maybe the next month, we'll see a draft regs from the Bureau of Cannabis Control addressing delivery, and they'll give everyone a lot clearer idea of what they're going to have happen. I should say, not draft regs; they're going to be the actual regs, at least for the time being. So I think we'll know a lot more at that time. That's a very interesting and large part of the market right now.
So who's affected most of all the kind of players in the from cultivator through to retailer and even consumer? Who has to change their kind of behavior the most? I think under the new regulations.
I think the biggest change is for distributors. So previously, they required, as I mentioned before, they required an independent arm's length distribution all along the chain of distribution. So a lot of people were concerned. You get the folks who do alcohol distribution stepping in and trying to replicate that model. But now the new system, you still need a distribution license, but the cultivator can have their own distribution license. So I think what that is the fundamental change. If someone had the idea, hey, everyone's required to use a distributor, there's going to be a limited number of licenses, I'm going to lock that up. I think that business model, that's dead. I mean, you're going to have to provide value. You're going to have to, and distributors are still needed, but it'll be a lot more competitive because they can be owned by anyone in the value chain. So I think whoever can do it efficiently and well is the right answer. I assume most of the large-scale cultivators are going to have their own distribution company, or own distribution license, just because it's efficient. And I suspect the same is true of most of the large-scale manufacturers. They'll just do their own distribution. In fact, many of the manufacturers are already doing that because they have these dispensary relationships, and then it's natural for them to pick up other products and move them through the same channels.
So you're kind of starting to get into the realm of vertical integration. Anyone that's been watching the Canadian market knows that it's fully vertically integrated. The people planting the seeds are the ones delivering it to the customers. How has that changed over time with California? Because it used to be a very segmented market. If you were growing, you weren't distributing, and you weren't moving product. How's that going to change in 2018 moving forward?
So under the old system, vertical integration was not permitted. There were limits on how much, if you were a cultivator, interest you could have for example, manufacturing or retail. Those limits are all removed. So at this point, it's totally open season as far as someone could have seed to sale. The one thing you can't have in the chain is lab testing. The lab needs to be independent, which I think makes sense. So you want arm's length independent testing that's verifiable. You don't want them owned by the same guy who's paying for the testing. But everything else can be open. So there's no constraint, at least in the statute, that says the same guy can't have significant cultivation assets, large-scale distribution, and a bunch of retail stores. And we've seen that in some of the other states too. Oregon has a ton of vertically integrated large-scale folks, and I suspect we'll see that here too. We have a big market. How it shakes out, I don't know, but it's allowed for the first time, which is a change from the original medical system. The other thing I would say is, under the MCRSA, the draft regs had some caps on the size of cultivation facilities. So there's individual license caps, but they also impose, hey, no one company can have more than 4 acres of canopy. And there's not a clear statutory basis for that under the old medical system, but that's what the draft regulation said. I think the language in the new Malcursa makes it harder for the regulators to do that, because it's an express statement that there's no limit on the license types that any one person can have, except with a couple of exceptions. But I wouldn't be surprised if the regulators still don't impose some cap on the amount of canopy that any one person could have, at least in the first couple of years. But we'll just have to see about that. 4 acres is a lot anyway, realistically.
Sure. So I think you're seeing now, it sounds like we all kind of know that even though you're not supposed to own cultivators and dispensaries all under the same roof, there's some legal shenanigans that happen now anyway, so that the same kind of group of people control that whole value chain. I imagine that will unravel a little bit, or at least just come out into the open about it, and it's like, okay,
yeah. I mean,
this is what we've got now.
I would say under the system we have today, if someone's in business, it's supposed to be a closed loop from the cultivation to the consumer.
Fair.
So if you look at anyone operating business today, it's supposed to be a collective operating on a nonprofit basis where everyone involved is a member of the same collective, and all the cannabis is exchanged only in exchange for value provided. So I don't think there's any current prohibition on vertical integration. In fact, I would say it's supposed to be necessary. The MCRSA licensing did do something to segregate the market. It didn't prohibit vertical integration entirely, but it imposed some constraints on it. For example, there was a license type which was 3 dispensaries distribution, or 3 dispensaries manufacturing and retail,
right?
Or manufacturing and cultivation.
Yeah,
which just happened to match exactly what Harborside had when the license got passed.
How convenient.
Yes, exactly. And so they said, hey, you can vertically integrate to that extent only. 4 acres of canopy, 3 stores, but that's it.
Got it.
That doesn't exist anymore. So it could be whatever, 12 dispensaries and 12 acres. We'll see what the regulators say, but hypothetically, there's no limits. So I think you may see. I don't think anyone's surprised to hear me say the long-term trend is likely to be concentration and roll-ups in the industry. I think you're going to see a ton of dispensaries coming under common ownership. You're going to see a ton of cultivation coming under common ownership in manufacturing and operation, just because it's efficient. And capital is hard to come by in the industry. And so I think that's the future. And the question is, what's the business model for smaller players, and how does that work? And I think that's a lot of interesting action over the next few years. Let me add on that point. One of the other things that Malcursa added, which didn't exist before, was the cooperative model. So what that allows is a bunch of small independents to band together under one cooperative and have certain shared functions.
Do they share a license somehow, or
they don't share a license, but they can do common marketing. So you'd have each, like for example, the model is designed, I think, primarily for cultivators. So you'd have a bunch of smaller cultivators who each have their own licenses, but they're allowed to sell together. In a standard agricultural co-op is the model. Right. And so that way, while it doesn't solve their problem of the cost and difficulty of licensing, it does allow them to get into the medical system or the recreational system more efficiently through a single point of entry.
Can you walk this back for a minute, because I'm confused about something, which is common. What was prohibiting them from doing that before. Why do you need special permission to have a co-op?
I don't know that you necessarily would. You could probably come up with a creative structure to accomplish that if you are willing to pay a lawyer enough money. But I think what this does is give a clear roadmap that says, hey, if you guys all want to band together and sell your product all together and through one unit, here's how you can accomplish that. Otherwise, the system, the licensing system contemplates that every cultivator would be responsible seed to sale for their product, and so that means individual negotiations between the cultivator and the distributor or the manufacturer, whoever's buying the product. And this way, you can hand over the ability to negotiate to your co-op, who can try to get the best prices based on the negotiating power of all the members, rather than just the individual.
So it's an explicit collective bargaining kind of thing.
Yep.
Okay.
And ag co-ops are very common in California anyway for other other commodities, and so I assume that's where the model came from. Okay. And I know that the folks in Humboldt and Mendocino were some folks up there were pushing this because as a way to be able to compete against the larger scale growers in other parts of the state who may have kind of more industrial scale.
Right. Obviously, the larger the grow, the more leverage you have to negotiate, and so if you can band together, you get the same leverage.
Yeah, exactly.
Got it.
So we're pretty used to the tension between the federal government and the state governments and kind of like the difference in the laws regarding cannabis there. Mm-hmm. But within California and within pretty much all the states, you have a similar tension between the city level and the state level.
Yeah.
Is there anything in the new regulations that are kind of cleaning up the disparities between the different cities and how that's managed?
So there was one change. I don't know if it cleaned it up. So under the medical system, you needed affirmative permission from your local government to engage in commercial cannabis activity. Under the Prop 64 model, you didn't need affirmative permission, but your conduct still had to be authorized by your local jurisdiction. So you could conceivably have a city or a county for the unincorporated areas that just did not regulate at all, did not pass a prohibition. If their zoning allowed it, then it could be permitted. In practice, I don't know of any local jurisdiction that has consciously decided, how are we going to deal with cannabis in this county? We're just going to treat it like anything else with no special requirements or permitting. No one's going to do that.
You'd still be subject to the state rules, though, so it's not like it would be completely unregulated. It's just there would be no additional county regulations.
That's correct. No additional county requirements. And so at the county level or the city level, the key issues are zoning, building permits, and so where a lot of the activity is, among my clients and other folks in the industry is going through, getting a conditional use permit for whatever they want to do in the jurisdiction that they're at. And it's the same thing that any other land development would have to do, except that because it's cannabis, the county is, or the city is really focused on it, maybe adding some additional requirements. And then the other thing is in most jurisdictions, the reason the city or county authorizes this is because they're adding a special tax. And so to make sure and that creates mechanisms for enforcement because everyone wants to make sure their tax is being paid. So typically they will require some kind of permit and some kind of reporting requirement. So just as an example, Monterey County is a hotbed for cultivation. So they require, there's a conditional use permit process, and then there's a business license process, and then there's quarterly tax reporting. So you got to, cultivation pays $15 a square foot a year, and you got to pay that quarterly. And so every quarter you send in a form that says this is how much we're cultivating, this is the square footage, and then they calculate your tax pay, and you got to go pay your tax bill every quarter. And if you didn't have a permitting process at the local level, it's kind of hard to do that because you don't know who's doing what. Right. And I suspect we'll see that model roll out, in additional jurisdictions as they decide to move forward. There's a lot of activity at the city and county level. People deciding what they're going to authorize, how many, what their process is going to be about who gets a license and who doesn't. And so a lot of interesting stuff happening right now.
Do you have any concern? I mean, perhaps it's just my politics that give me heartburn over this, so maybe no one else has heartburn. But do you have any concern that because the cannabis industry is kind of in the zeitgeist right now, and everyone kind of views it as a get-rich-quick scheme, they see like a lot of money, you've got these cities and counties kind of, where's my cut? And likely to kind of implement regulations that actually are going to make it very difficult to do business in that city or county at all, because it's actually not as much of a cash cow as is kind of portrayed in the media.
I think that's right. I think a local jurisdiction could price themselves out. And so, let's set aside retail for a second, talk about manufacturing, cultivation, distribution. Those could be anywhere. They don't there's some areas that are prime for cultivation, but manufacturing, you just need a building. There's no special sauce to that, right? So if one jurisdiction has lower regulatory barriers, has lower tax rate, then that's obviously going to be where people locate. It's just common sense. Cultivation, it's the same thing. So I do agree that in the long run, there's going to be competition among local jurisdictions for the business. And so the ones that will attract business with availability of real estate, with availability of a suitable labor market, with a reasonable regulatory structure, and on the tax rate. Right now, there's so few jurisdictions that are actually giving out licenses for cultivation and manufacturing. If someone wants to get in the business and be open for business in the recreational market January 1, 2018, there's not a lot of choices.
Right.
If you want, I get probably the number one call I get, people asking the question is, where can I get a license for activity X?
Okay.
And typically, it's a very short list. And so if you want your license, you got to go to those places. Now, in the long run, more jurisdictions are going to open up and there's going to be more competition. And I think that will mean that the cities and counties are going to have to, if they decide they want to have these businesses in their community, going to have to offer a reasonable regulatory structure and a reasonable tax rate. But right now,
you can kind of get away with anything,
market.
is what you're saying.
Yeah,
Fair
it's
enough.
a seller's
Okay.
market. Now, the other thing I would say is retail is a different thing because that can't be everywhere.
Right.
That's this location. So that, I think the cities and counties can extract a lot of value out if they want to do that. Now, obviously, if you have a lot of different local jurisdictions in close proximity to one another, that is reduced. But if you have Fresno, for example, it's a huge city, both in terms of people and in terms of square
Nothing around
miles.
it.
Right, and there are some little communities, and there's also unincorporated Fresno County, but not a ton.
Right.
So, basically, if they wanted to allow, I assume businesses would allow businesses would be willing to pay an extraordinary high tax rate for the privilege of opening a dispensary there, especially if they had limited competition, because there's not an option. The people of Fresno, if they want cannabis, are going to have to go somewhere else.
Right.
If that doesn't exist. So I do think you're fundamentally right. But look ahead 3, 4, 5 years, then you'll see these things happening.
Okay.
Interestingly, there's a move in Monterey County among some of the folks in the industry to try to get the city council to lower the tax rate. And I have to say, it's not like the industry is being strangled in the cradle down there.
Not yet.
The argument that this tax rate is too high and we can't pay it is hard to reconcile with the massive construction and millions of dollars of investment that's happening. I mean, I think in the long run it probably is too high. It's going to have to come down. But right now,
Yeah, I
think
mean,
it's a
look,
tough
when
argument.
plant prices come down and margins get thinner, then you're going to start to see this stress is in the system that you might not see right now.
Yeah, I agree.
Because there's just a lot of fat right now.
And I assume a lot of people will just fail. There's a lot of businesses that are going to spend money and then they're going to fail, and then the counties and cities are going to have this, maybe this greenhouse or this manufacturing facility with no one in it, and no one else is going to want to take it over and pay, whatever the high tax rate that the city has set for it. And that will encourage the city to be like, oh, geez, if we want someone in there, we're going to have to be a little more reasonable.
So another concern that I've heard about county regulations or city regulations is with respect to delivery, not even necessarily to consumers, but let's say I've got to get product from Humboldt to LA. Let's make a worst case almost for San Diego, right?
Right.
The concern is that there's a county that just says, oh yeah, you can't drive through our county with cannabis, and then what do you do?
Right. So right now, there's not a lot you could do about that. Once you have a state license, there's actually a provision in the state law that says that the county or city cannot prevent use of common roadways to go through.
Oh, okay,
so
good.
it's-
I wasn't aware that was in there. That's just great. Okay.
So so I-5.
You can take I-5. You're safe. Okay.
Right. Well, you can take any road you want, and as long as you have a license. Thing is,
Right.
the number of people with state licenses right now is 0.
Right.
They don't exist. And so, if you're driving through Tulare County, and yes, you could get arrested. And there's, you have Prop 215 and Senate Bill 420 provide defenses against criminal prosecution if you have a appropriately run collective. But it's a gray zone at best.
Right.
So I certainly, think it's a real issue for people.
So nobody has licenses right now. You've mentioned January 1, and that's on everyone's radar. And I don't expect you to be a political Nostradamus, but what's the chances that California delivers on time? And when are we going to start seeing those first licenses? When are we going to see the first shop that you can walk into with a California ID and buy some cannabis?
That is a really good question. So one of the additional requirements, one of the additional programs they put in place with Mount Cursa is temporary licensing. And so the idea is someone who has a local license from their local jurisdiction could go to the state and apply for a temporary license that would allow them to operate while their real license application is pending. So I think that's the strategy to meet demand, or at least to start to meet demand in the first few months of 2018. Now the problem is there's very few jurisdictions that are going to have local licenses out at that point. Very few. Most, like Oakland, for example, has been working on this forever. We don't have a recreational or adult use licensing program in Oakland yet. It doesn't exist. There's
Where is there?
San Diego has one, and then there's a lot of They did that. They're one of the first out of the box, and then there's a bunch of places that are considering them right now, but most of them they're still in process. So I guess we'll see. I mean, I assume that all the counties that were way out ahead on medical, like Monterey or the places down in the desert east of LA, that they're gonna just say, okay, medical, adult use, whatever. Well, as soon as I think they're assuming they were waiting for the state regulatory process to get a little clarified. Now that it has been, I assume most of those places are gonna flip over to rec, but we'll see. We don't really know that. The other thing that has happened in some other states is if the regulatory system isn't working fast enough, they've allowed licensed medical folks to sell small amounts to rec. So that was a solution they imposed in Oregon. For example, they had an established medical market that was actually very similar to California's, lightly regulated, and then they rolled out adult use. And so they said, hey, anyone could go into a licensed medical shop and buy basically a small amount of cannabis just with an ID as a stopgap measure. And if you think about the current system we're in, so it's legal recreationally, without a medical card, to possess cannabis, to consume cannabis out of public, and to buy cannabis. You're just not allowed to sell it. So like, where are you supposed to get it? Like, I guess you could grow your own, or a friend could grow it and give it to you, but it's really a conundrum. So it's like a very logical answer is if our regulatory system isn't ready, is just to say, hey, let's let the licensed medical shops, sell in small quantities in the time being. I would much rather have them buy there than buy in the black market, which is the other alternative, right? Just being realistic about it. So I know that some folks have been talking about that in Sacramento. I don't know the chances that'll happen. I think that will depend on the reality of the situation with the licensing program as we get closer to the end of the year.
And how do you suspect that will be delineated once this all washes out, between medical and adult use? Are there going to be different shops, or is it going to be like, I have my medical license, therefore I don't pay taxes?
Right, that's a good question. So the current statute it's the same licenses, but there's a adult use type license and a medicinal type license, and it's one or the other. So any particular premises has to be one or other, but not both.
Interesting.
So if now when the regs will come out, I think this will get clarified. But my expectation is, so for a retail store, you could have one store that had a medical and adult use area, and then you could do transactions one or the other. But the product would have to be separate. There'd have to be some separate square footage.
Essentially, it's two stores in one store.
Yeah, I assume you could have some common services. So you know what I mean? Like you could have a common lobby and do security, and if someone has a medical card, you send them over here, and if they have just a driver's license, send them over there. I think there's some ways where you could make some facilities that would apply to both, but where the cannabis is actually sold and stored, that's going to have to be separate, at least under the current
storage
statute.
has to be separate. So this is the medical stash, this is the adult use stash.
Exactly. At least it may be that the regulations give some flexibility on that, but as the statute is written, that's what would be required.
And does that delineation stop there, or does it go back even further?
It's all the way up the chain of distribution. The one license type that's able to do both without any special treatment is labs. Labs can do both; they don't care. That makes sense. It doesn't really matter for them. But for a grow, like any given grow room, is that an adult room or adult use room? Is that a medical room? Which license type applies to it? And as that product is sold, it goes to the manufacturing facility. There's going to be a medical component to the facility and an adult component to the facility.
So this is actually a problem if you've got if you have a product that could potentially, and I'm talking about a refined product like an edible, that could potentially be sold for medical purposes or sold for recreational purposes, you actually can't make them in the same facility with the same ingredients because the ingredients have to be sourced differently because they have to be separate from the beginning.
And your manufacturing facility would have to be separately licensed also. And
Right.
in addition, I agree. Now, I think if we're talking about, like imagine 2 grow rooms next to each other, one medicinal and one adult use, and then it's like that's not going to make a difference to the manufacturer. Like
Right.
it's easy enough to switch from one to the other, but I think for the manufacturer, having 2 assembly lines and 2
Right.
extraction machines, like it does.
It doubles your manufacturing. Yeah.
I would say in the long run, the experience of the other states is that the medical stuff will just shift over, and that'll be the tail on the dog, and the dog is the adult use market.
Fair.
But in the medical market is transitional. The number one advantage from a consumer point of view of having a medical authorization in the future is you don't have to pay sales taxes.
Yeah.
But that's only true if you get the state ID card. Even if you just have your doctor's note, you still got to pay sales taxes. So and
Most people don't have the state ID.
Very
card,
few people have the state ID card. So my expectation is that's adult use is the future and medical is really transitional. The other thing I would say is there's a lot of movement to constrict the granting of the procedures by which people get their medical authorizations. Because right now, telemedicine is very common. It could be argued that some doctors are not taking due care in deciding what their patients need, and so right. And there's both legislation and draft regulations that would clamp down on that. So I think we'll see the number of people with medical cards diminish. It doesn't mean of course there are many people with millions of people with valid reasons to have a medical prescription in California, but I do expect to see the numbers shrink as the adult use markets opens. It's because it's like if you can get what you need, like why bother?
Right.
Right.
If you needed a prescription for aspirin, you'd go get one. But if you can just go buy it off the shelf,
so built into that, there's a big conflict, right? Because there are true medical applications of cannabis, and if we move everything to adult use, then are we going to kind of like wash over this whole opportunity where doctors could be prescribing cannabis instead of opioid drugs? Like, is the government like imposing? Sorry, I'm getting like. It seems so arbitrary. Well, it seems so arbitrary. Like, why the hell are we delineating all the way back to the grows when it's the same fucking product?
Yeah, I think there's an argument that it doesn't really make a lot of sense, but it's a system we have, and so I think part of it has to do with the logistics of getting this system off the ground, because they have Prop 64, which the legislature can't really change. I mean, there's certain they can wiggle around the edges, but they can't fundamentally change it. And then because it's approved by the voters. And then you have this medical system, which isn't really addressed by Prop 64, but which is the current industry in California. And we have to figure out how to move that into the new regulatory structure that the voters put in place. And this is the mechanism the legislatures chose. I agree, as a policy matter, if you were starting from scratch, I don't think it would come up this way. But this is where we are due to how this industry developed, and so I think they're just looking for a solution that works, that they can make legal, the legal framework that's supportable. But fundamentally, why you have 2 grows right next to each other? They're exactly the same, except for one is a type A3 and one is a type M3. Otherwise, they're exactly the same. Like, what's the point?
Right.
I will say, look, doctors recommend stuff that's not prescribed all the time, right? So my doctor advised that my son take peppermint pills. Okay, you don't need a prescription for that. You buy them on Amazon, and so. And I think there's nothing stopping a physician from saying, here's, I think cannabis could help you. Here's some specific products. The fact that you don't need the doctor's permission to buy them, it doesn't mean the doctor can't give you good advice.
So the argument here is that this is probably a temporary problem, and that as you say, it becomes the tail and the dog becomes adult, this kind of goes away.
Yeah, I think that's exactly right.
I guess the only concern is it says temporary, as most temporary government programs, which is...
it's fair. The other thing I would say is the other point of transition in 2018 is, what about the existing operators, none of which have state licenses? And how long can they operate without a state license? What's the deal? That's another common question I get. So the answer to that is, so under the previous medical system, there was a statute that said, hey, if you have a local license and you're in operation before January 1, 2018, you can continue to operate until your license application is acted on at the state level. So the idea is, hey, I'm a grower, I've been doing this a while, I have my local license, I'm going to file my state license application timely. Do I have to shut down while I'm waiting for the state? And the state was like, no. So you get your license application in timely, then you can operate until we decide. If we say no, your license is denied, you're going to have to shut down. But that was reasonable. The new system does not have that component.
Oh.
So the SB 420 protections for collective cultivation continue to apply basically up until the end of 2018, so January 1, 2019. And so that's a defense from criminal charges. But there are still civil and criminal penalties for unlicensed commercial cannabis activity. And so how this is going to work is really a bit of a question mark at this point in time. I think that's the purpose of the temporary licensing. I think my hope and expectation is that, one, the state draft, this next round of regulations will tell everyone what they need to do, when they need to apply, and whether they'll be given some grace period to get in the application system. And two, it's my hope and expectation that they're going to give out these temporary licenses to accomplish the same thing. It's like if you submit a fully formed application for a real license, we'll give you a temporary license while it's pending, and then you're covered. I think that's the plan, and we'll see when they come out with the draft regs. But those things do require a local license. And the number of people who have a local license at this point in time is very, very small.
Right.
And so there's a lot of pressure over the next 3 or 4 months for people to make it through the local licensing system so they can participate. Just as an example, so Sonoma County had a kind of forgiveness program where, like, hey, if you're cultivating in unincorporated Sonoma County, we need you to apply by date X, and if you do, we'll give you some protections. And then they had a huge firestorm of growers coming into the city council or the county board of supervisors saying, we've done our best, but we just can't meet the deadline, and now they're talking about extending the deadline. So I suspect we'll have a lot of the same things happening because cities and counties are struggling to implement these programs. The business people are struggling to make it through the programs, and so if we want to have a functioning system on January 1, a hard requirement of a local license is going to be really tough for people to meet. So that's something I really have my eyes on.
So people think of rec. I think they have this idea that they're going to be able to walk into a 7-Eleven and buy some cannabis off the shelf. Is that true?
No, so you have to be a licensed retailer.
Right, but could they get are there restrictions on being a licensed retailer? Could 7-Eleven be like, yeah, we want our license?
Well, they would have to stop selling beer, so that's probably a business killer from a 7-Eleven point
Fair.
of view. You can't sell
Maybe
alcohol.
not. Maybe I chose a bad example, but yeah.
I mean, the reality is the difficulty of especially retail licensing, which is in almost every local jurisdiction, is just a huge lift. And even in the most supportive jurisdictions like San Francisco and Oakland, getting a retail permit is a big challenge. And so if someone who is just a sideline is very unlikely to want to do the work and spend the money it takes. Now, maybe they'll get easier over time and you can see it. But right now, the people who are the most likely scenario for a retail store is someone who is 100% focused on cannabis. That's their primary business. It's going to be new. Now, I could see someone who's got another business like wanting to add it to their product array. But the only reason, the expense of doing that is so great, it would only make sense if their existing business.
Or maybe even the other way around, where a cannabis business starts as 100% cannabis and realizes, like, oh, it's a good idea to sell Cheetos and some other things, and we're going to start throwing on some. Oh,
for sure. Like, I definitely think we'll see, like, look, if you've got a waiting area at a cannabis retail store, like, you should be selling coffee in there, right? I mean,
yeah,
it's like now, I mean, it's retail space is expensive, right? So, like, people want to minimize that, but at the same time, yeah, there's also huge tax benefits to having a non-cannabis line of business for your cannabis company.
Yeah.
So, that's a factor also. So I think we will see that. It's just right now, it's so hard to do the cannabis piece. People are focused on that, and they don't really have the bandwidth to do the ancillary stuff.
Are there any other kind of common questions that you get that we haven't touched on at all today?
No, I think that's the fun. The two I get are, where can I get a license, and what happens next year? Can I continue to operate while I'm in the transition? And those are the two we covered. So we got it.
Well,
Awesome.
and I think the important thing is, like, pay close attention. Do your homework and make sure that you are going by the book, because, I mean, I don't want to go into this because it's a whole nother discussion, but the federal government looks for any opportunity they can for people not aligning themselves with the state laws, because that's where the weakness is in the legislation, right? It's so keep your head off the chopping block.
on that point, so each of the state regulatory agencies, the Bureau of Cannabis Control, Cal Cannabis, which is the Department of Food and Ag's cannabis organization, Public Health, which does manufacturing, they're all going to be issuing emergency regulations sometime this fall, or late summer, early fall. So two things. One, that's a huge opportunity to see what the businesses are really going to look like. That's the details about compliance that people have been waiting for. You can get some idea from the draft regs that are out now, but this is going to be the real thing. If you're in the business, look at them, make sure you understand them. The other thing is, those are temporary, right? They're emergency stopgap regs that are designed to facilitate development of the real regulator. So the industry needs to do, I think, a better job of collecting feedback and offering it to the regulators to get common sense regulations. I will say the number one issue that I saw people giving comments on the last round of regulations was the permitted size of dosage in edibles. Like there was it was 10 milligrams per serving, 100 milligrams per sold unit was the thing, and a lot of people were very upset about that. And I have to, and which is fine. I get it. I understand some people need a higher dosage for very valid reasons. Of all the things in the regulations to focus on, like politically, that's like absolutely the worst one.
Right.
It doesn't mean we shouldn't have been giving feedback on that. Sure. There's a lot of other stuff. So I think that we can do better as an industry to figure out, hey, where in those regs are we really likely to make some improvements? Mm-hmm. What are the arguments that are going to be persuasive to the regulators? And how can we show them, hey, here's a better method to achieve your goal that is easier for us to comply with and serves the public interest better? Yeah. I think they're open to that. They want to hear the feedback. And I think we can do a better job of giving them feedback that's helpful and more likely to move the needle in a helpful way.
They'll just have to eat 10 brownies instead of one.
That's right.
If that's what they need.
So do we have any, should we go to the audience for some questions? Do we have any questions from the audience? There we go.
Hey, how's it going?
Good.
So the quick question that I had was like, I was thumbing through some of the legislation documents, and I was kind of curious, how does this affect like companies like mine which sell devices? I noticed a section in there about vaporizers, pipes, water bongs, all that type of thing. Is there any legislation there that affects where, when, and how?
So non-plant touching, like
or just hardware, like
just pure hardware.
So one of the things that Prop 64 did is legalize cannabis paraphernalia. So there are some requirements in there, but I don't think the new Malcursa changes any of that. So I will say I haven't looked carefully at that issue, but it's not really regulated by the three regulatory agencies. It's really outside their domain. So at the state level, I think you're pretty good. But we could take a look at the specific language of the statute on drug paraphernalia and make sure that that's right.
Sorry, and if you don't mind, I just have one more.
Sure.
How is it that, like, California obviously is not the first state to legalize cannabis. There's been quite a few others. How is it that they're still kind of stumbling over the regulations in this, given that we have 6 other states to look at for, history of what they've done and how they've implemented it?
2 words: complexity and politics. I mean, it's a big program. We're the biggest state by far. We have an existing industry that's enormous, much bigger than any of the other states. Mm-hmm. And we have a complicated and somewhat dysfunctional political process in California. So I think that's the real reasons. I have to say, I think they're doing a reasonable job. I mean, it's not going to be smooth. You're building an entirely new, heavily regulated system from scratch. Okay, and that's a big lift. So I'm not going to make any excuses for the regulators, but they're working within specific parameters. They have to do what the legislation says. So just as an example, they spent a year coming up with the draft regs under the previous medical system, and that was their job. They didn't know what the legislature was going to do. Mm-hmm. 3 weeks after they released their draft regulations, the state legislature fundamentally changed their job by changing the statute that they're implementing. And there's nothing more Ajax can do about that, right? And so, they're going to take some time to get the new regs rolled out. It's understandable. I guess maybe the fundamental answer to your question is to take it to the legislatures in Sacramento. They're really responsible. That said, we've got some great people who are really looking out, trying to make this a reasonable, regulated industry. And the spiel I always give is California needs to be a leader in doing a good job of this, meeting the real public goals, which is eliminating. I want California to serve as the model for when we have an argument about what's the most effective way to deal with drugs and addiction in this country. Is it the Alabama model or the California model? I want California to be awesome and to be a role model for how well this can work to generate tax revenue, to reduce access by kids when outside of medical need. To help all the public safety measures that are needed. If we're doing a great job on all those things, then that political discussion in Washington is going to be so much easier. And so, I think we have folks in the legislature who agree and who are trying to push that agenda. But there's a lot of individuals and they have their own constituencies. There's been a little infighting in the industry too on who wants what. People are not 100% aligned in the industry, and so that's also a factor.
Oh, Ringenberg for governor.
One more question.
Hi, Kieran.
Awesome.
I'm not sure if you're totally aware of it, but some of the letters that have gone back and forth between sessions and like the state's attorneys generals in Washington, Oregon, and Colorado, and also their governors. Do you think that we're going to see some similar moves from California for protections of state rights from federal enforcement?
I mean, so I'll be very clear. Those letters, that's political grandstanding on both sides. That's what that is. It's not legal. It's really just, Sessions is trying to make a political point, or his team is, and the governors and the attorney generals of the states are trying to make a political point. I happen to agree with the governors and the attorney generals in those political points, but that's what that really is. You may have also seen Kevin Sabet's organization, which is like an anti-marijuana, supposed public policy organization, released a report yesterday or the day before, criticizing along very same lines the existing Colorado, Washington, Oregon experiences, and saying, making arguments that access to kids is up, highway accidents are up, et cetera, et cetera. And so that's the discussion. I was actually talking with Carter before about whether or not the argument about marijuana legalization is won in this country. I feel like a lot of people think the argument's over and it's inevitable. And I think in the long arc of history, that's probably correct. But how is that going to happen and when is that going to happen is very much up in the air. So that's one of the reasons why I think the industry needs to accept and embrace reasonable regulations and go above and beyond them, and so that we can be an example, and so that we can take that performance into the political discussion and just roll over the drug warriors who are pushing an agenda that obviously has never succeeded. I would I actually saw it as a Twitter comment by this Sabet guy, and he's like, had a survey about what percentage of people had illegal drugs and what percentage of people had alcohol. And obviously a lot more people have had alcohol than illegal, or a lot more people are willing to admit that they've had alcohol than have had illegal drugs. Mm-hmm. And he was like, oh, this proves that this is working. And I'm like, yes, making it a crime will reduce usage, right? Okay, but at what cost to society? There's no, in my opinion, there's no plausible argument that the costs are worth the reduction in usage.
Well, it's also weird if you're like, hi, you don't know me, I'm taking a poll, have you committed a felony?
Right, exactly.
It's like, well, no.
Right.
Have you had a beer? Yes.
Well,
okay.
Yeah, no,
it's working.
Right. But fundamentally, that's what this public policy debate is about. And so it's like I'm trying to spread the gospel about embracing and the nature of regulations. This is going to be difficult. There's money to be made in the industry, okay? But there was a lot more money to be made before when it was purely a black market product. And the goal of this move, in my opinion, the goal of this legislation is to eliminate or substantially reduce the black market, and that means that some people are going to lose their cash cow, and that's going to upset some people, but this is what it is, and we just got to accept that and move on.
Yeah, no, I think
that's the cost of
right.
legalization.
Yeah, I mean, in exchange, you get a decreased risk of being thrown in jail.
Absolutely,
fantastic.
So,
right, tested product, better product, innovation, all that.
Yep. Cool.
Hi.
Any other? Oh, you got one.
Yeah. Hi, Karen. I just wanted to ask about the social side of bringing marijuana into adult use, and what do you see happening there? I mean, I would love to be able to go to a concert with friends and be able to openly have marijuana. How do you see that transitioning?
So one of the components of the Mount Cursa legislation is to set in place a public consumption licensing scheme, so local jurisdictions can allow that within certain parameters. So that's happening right now in Denver for the first time. So it's taking applications for people to do social consumption in specific venues. So I think that's the step. It's funny you say I'd like to be able to consume cannabis at a concert, because it's like, I've been to a lot of concerts, and anyone who says it doesn't happening is like, it's insane, right? So. Do I think that will continue? Yes. It will continue to be ostensibly illegal, officially illegal for the foreseeable future in public? Yes. I think it will be. The legal requirements in California for public consumption are going to be, kids can't see, it has to be closed venue, and kids won't be able to see it. That's the essence of it. And so that's, at the Greek Theater in Berkeley, you'll never be able to meet those criteria. But I was there earlier this week, and there was no shortage of cannabis being consumed, as has been the case for 50 years.
There was marijuana in Berkeley earlier.
Yeah, at an outdoor music venue. Can you believe it?
My goodness.
Crazy.
What's the world coming to?
I'd like to piggyback a little bit on that. one thing that I've seen a spike in are the infused meals, and I'm wondering how they are legally able to do that on site.
They're not. I mean, you know, like if you're, I mean, if it's a public, if it's like a restaurant or a park, then like it's not allowed. I mean, legally, it's not allowed.
Privately
Right. If
it
you're
is.
your own home, you could do that. Sure. I think if you're making a business out of it, that's a little bit dicey. I think there might be able to structure that you could do it within the legal guidance, but I think you'd have to be really careful. You know, I think having a potluck with your friends over where everyone brings cannabis infused food, nothing wrong with that. That's not commercial, you know. But the minute you start charging for it or having it at a public venue, probably not legal.
Gotcha.
Great. Any other questions? All right. Well, we've run out of time.
Great.
Anyway, why don't you tell people how can they get a hold of you?
So ringenberglaw.com is my website, and contact info's on there. On Twitter, I'm at Cali Legalized. So I try to. I'm focused right now on all the activity at the state and local at the local and county level, which is where a lot of the action is. So if you're trying to keep up on that, that's a good place to go.
Awesome. Well, thank you for coming.
My pleasure.
Really
Thank you,
appreciate
guys.
it. Ben, do
Thanks
you
so much,
you have
Karen.
any things to talk about that you didn't say at the beginning of the show?
Yeah, so
Perhaps?
all right, fine. Housekeeping. If you are a cannabis startup, a new cannabis startup that hasn't been through an incubator, accelerator, or has gotten funding over, I don't know, a couple $100,000, apply to our pitch competition. We're giving away $10,000 at New West Summit. It's October here in Oakland. nws.gtwy.co. Talk about alphabet soup. Holy crap.
Right.
Anyways, NWS stands for New West Summit, and our website afterwards. Yeah, apply. We're looking for the 10 best startups we can. We're going to get you up on stage, panel of judges, quick fire. It's called a pitch slam. You don't get to answer questions. They just get to give you feedback.
Yeah. And you can catch us every week, Fridays, 10 a.m. on Facebook here, and then we're on YouTube, and we're on
Podcast. Subscribe to our
Podcast,
podcast
on
and
iTunes, yep.
uprate us and all that kind of stuff. We're supposed to ask people to do that. That's the
Oh, yeah.
social media hacking.
Yeah, do all the things that you're supposed to do.
Yeah.
on
Listen to
social
other
media.
podcasts and then do that for ours.
Yeah.
Because that'd be great.
Do that.
Awesome.
All right. Thanks.
See you next week. I will, not him.
Right.
All right. Bye.